Hello everyone and welcome to this new episode of the PrivacyRules Privacyespresso series, a series where we go through the latest news on privacy, data protection, and in general technologies from all over the world. And we do that with the experts, at least in most of the cases, of the Privacy Rules Alliance, a global alliance of experts in these fields. And the expert I have with me today is Volker Wodianka from the German law firm Wodianka Privacy Legal, that is also member for Germany, of course, of the Privacy Rules Alliance, because we're going to speak about some news coming from the country, in specific from the Hamburg Commissioner of Data Protection and Freedom of Information, that has recently released a new discussion paper related to general data protection and LLMs, meaning large language models. That is something very close to the topic of artificial intelligence. So without further delay, Volker, thank you for being with us, and please provide us with a quick overview on what we are talking about and what is this discussion paper about and what is a discussion paper in general.
Yes. No, thank you. I think everybody is looking at the moment at official statements, or in this case, a discussion paper from authorities, in this case, a German data protection authority based in Hamburg. And they released a discussion paper on the relationship between the General Data Protection Regulation, GDPR, and the large language models, LLMs. And this is still quite rare, and not often that authorities now make or give this input with, of course, technical and legal expertise. And it's also interesting to read these kind of papers in the light of the just announced statement of the European Data Protection Board in terms of how to position data protection authorities in the future as the, let's say, market surveillance authorities, MSAs, which is a requirement pursuant to the AI Act. So it is kind of expected that many member states in the European Union will appoint and designate DPAs as MSAs. So because they kind of bring a lot of technical and legal expertise into these topics, and a core topic that we can dive a little bit more deep into here is, of course, whether GDPR applies to what area of AI systems and large language models.
Which I believe is the main topic of this document, the combination between LLMs and GDPR. So maybe exactly. You can give us a bit more overview or details into the statements and the position on this regard.
Exactly. I can only recommend, and we of course gonna link the paper in the video somehow in the comments. There are three relevant statements there, and one is that I actually know also from my advisory practice that you always discuss what about the large language model itself. Does it constitute processing within the meaning of GDPR? No. Does this model qualify as data processing as we know it? Because that's, of course, a big challenge to say when the large language model is regarded as data processing. Usually the providers regard that area of technology as something they want secrecy, and they don't talk too much about it. It's their black box. So it's a natural conflict to go with requirements under GDPR to these large language models. And the Hamburg authorities say, well, they think that the large language models do not constitute data processing. And this is, of course, a big statement. And don't forget, it's part of the discussion. And maybe not the last word, but it's an interesting argument that they do here. The second one is that, of course, data subject rights, as we know, DSR is super relevant under GDPR, and the authorities say that it would not relate to the model itself. So naturally, it's a problem to ask for information, for access, for deletion, for or correction when it comes to the large language model, which is so-called black box for most of the providers. and the authorities kind of exclude that area from the data subject rights. Yeah, it can relate, of course, to the AI system itself, but not to the large language model. That's the opinion of the authority in that area. And last but not least, of course, the AI system itself must comply with GDPR. Yeah.
Which makes sense. Thanks a lot for this picture on which is the position of the authorities and the key points in relation to that. Of course, this helps understanding a bit which is going to be the approach of what is going to be potentially the authority taking decision on this topic at the German level. In this regard, in your expert views, which are the consequences of this document and this approach, and what can companies expect or should do on the practical perspective?
My point of view here is really that the Hamburg paper is regarded as a very relevant statement in the environment and discussion at the moment. There's not a lot of statements in parallel to that. We saw something from the Danish Data Protection Authority at the end of last year, Data del CNIT, on large language model and GDPR, which kind of is, so far as I understand, in line with what the Hamburg authority says. But if you dig deeper into that topic, you find a lot of other opinions that say this argument is not correct, because we look at, of course, technical discussion here. And basically, the Hamburg authority argues that GDPR would not apply. It's not data processing of personal data, because we talk about basically tokens that are only pieces and fragments of a word, and insofar could never build a personal data as such, because it's only fragments and it's not even full words. And there are a lot of other views that say basically that could be true, but there are also a lot of situations, technical situations and training models where the results are different. And there are actually full words, especially in the area of people that are publicly well known, where the model understood that it's not a fragment, but it's the full word. And this is a discussion I can only recommend to follow, and don't see that Hamburg paper as a final opinion. It's a important discussion paper that is very interesting to read. Yeah.
Okay, thank you very much for this. Of course, Volker, the hope is that the various authorities will be aligned in the positions that they are going to have in relation to LLM and AI, as we know that they are relevant, and companies have to follow them country by country. So
I think we can add one thing here. Of course, for companies, it's important that, or it's a positive view when an authority would say the large language model would not fall under GDPR. So you only have to make sure that your AI system is GDPR compliant, but the LLM model is not in the view or in the surveillance of the Data Protection Authority. So I think that's an important takeaway here at the moment. So
yes, I think you cannot give it for granted, which is the position of the authority. Of course, in those cases, the best that we can do is following up on what's happening, which are the various positions of the authorities. Of course, I very much look forward to learn more on which is the Hamburg position or the position in Germany. But of course, we will keep monitoring the entire European Union, and even other countries that might be taking similar steps in relation to technologies and artificial intelligence. While waiting for that, I would like to thank you very much for being with us today, as well as our audience for following us and joining this Privacy Espresso episode. So thank you all. I very much look forward to meeting you all with our next episode. Bye, everyone.
Thank you, Alessandro.